court and what case and what the judge says. So let's talk, Greg, about some of these major cases and start with the decisions on whether to allow cameras in the courtroom. Media can't just go to a major case, show up that day and say, hey, we're here.
No, you can't. You know, it's interesting looking at the court TV SAT truck down at the courthouse this morning. They're in town covering a case. You know, we did not have cameras in the courtroom until the early 90s. And it was very interesting. One of the first televised cases was State versus Michael Frazier. It was called the Love Triangle. And that was the first time that right after Rule 30 changed, that's the rule allowing cameras in the courtroom, a case was televised on court TV, and it was here in Knoxville.
We remember that case well.
I remember it was kind of daunting because getting critiqued by Nancy Grace on your cross-examinations, like all the icons. But then, you know, throughout the years, think how cameras have changed and impacted the courtroom, society. When you have the O.J. Simpson case, now cases like Casey Anthony, Johnny Depp. I mean, it's really remarkable how you know, basically the concept of the constitutional requirement for an open courtroom has just transitioned into theater.
Well, it's tried in a courtroom and now in front of public opinion, and people do weigh in on how they feel, whether they're there or not. They're watching, and boy, people are into this.
And Greg, I think the first thing we probably ought to talk about is balancing that need. You know, we do exist in a world of open courts. That actually probably that goes back to common law, but there have to be a balance struck between the needs of the public to see what's going on in the court and the justice that's done in their name versus the rights of the individuals, those accused, and those other participating. So if you would, let's talk about Rule 30 and how the people, how the judges, and how our leadership sets the parameters for what can and can't be put on camera.
Well, you know, it's interesting. Normally when I'm involved in talking about this, it's a panel of lawyers, and you guys are the enemy because we talk about media in the courtroom, and Rule 30 actually gives the media standing to challenge a judge that tries to limit media coverage.
Because it says shall.
It says shall, but there are 4 circumstances in which the presiding judge can limit it. And those are to control the conduct of the proceeding. You don't want a circus. Maintain courtroom decorum, prevent distractions. And this is the big one that I see frequently. Guarantee the safety of any party, witness, or juror. And then the catch-all that's in everything, make sure that the administration of justice is fair and impartial. So, you know, that's kind of the dynamic and the rubric that the judge looks at. But when I say, I don't want you guys there, I don't want my witness to be intimidated by these cameras, have safety concerns, then there's a lot of work to be done. Media has standing to contest limitations on courtroom coverage, and there has to be a hearing, and there has to be a very high burden for the party that's trying to limit it. So there's got to be a standard of substantial evidence. Then the judge has to have an evidentiary hearing. Then the judge has to author a written opinion. So it's really interesting, Jeff. You know, when we see the issue of media in the courtroom, people think the lawyers and the media are all in lockstep and on the same side. But frequently, we're at loggerheads. You want in, and we want to shut the door and keep you out.
We want the public to have a right to know what's
Absolutely.
happening behind those closed doors.
But
there are times when cameras should not be there.
Certain things
and that's
you just
hard to
can't show.
say, but it's for people's protection. Let's talk about those here. For example, jury selection. You're not going to have a camera there to show that.
It's a no-brainer, and everybody, I remember trying the first case on court TV, State versus Michael Frazier. Everybody was worried about the jurors. Judge was worried about the jurors. You just simply don't point the camera near the jurors. You don't call them by name. And Tennessee, unlike federal court, you can't address jurors by their names. So what judges typically do is frown on media coverage because it kind of gets a little personal and can be intimidating when you're going through the voir dire process. But, you know, interesting, you know, even trying that first case on court TV, the cameras were overwhelming. They were in the corner of a courtroom, and now, you know, fast forward from the early 90s, technology has changed such when I tried a case, the 90-Day Fiancé case. I actually forgot we were on TV because they had literally a camera that was as big as a cell phone on a tripod.
So there goes the argument that this is
intrusive.
distracting
Yeah.
and intrusive.
But on the other hand, recently tried a case and a witness felt threatened, the prosecution said.
Just
So-
knowing somebody was there.
Well, no, they felt threatened just because of some dynamics in the case. And so what they wanted to do was limit the media coverage. And I did not want to limit the media coverage because it's an open proceeding. And if somebody is compelled to be there to tell the truth, they need to do it openly and publicly.
Let's talk about, though, some of these really sensitive cases. You have sexual assault victims, the Me Too movement testimony, things like that. And some of that was in open court.
Yeah.
Others did not want to testify publicly, and you can certainly understand that.
Right.
But let's talk about
And-
that aspect.
And
of it.
actually, in this recent case, there was potential litigation over whether someone's face could be blurred out. You know, the famous, little blob. What do you call it, Jeff? What's the technical term for the
a
fuzzy
Pixelated,
face?
Pixelated. Yeah,
Pixelated.
Yeah.
We actually almost litigated the issue of whether this witness's face would be pixelated, but I wanted to be able to cross-examine this person, and I wanted them to be able to tell the truth. I wanted them to see that their words had consequences, and that they knew to tell the truth, that they were under a Hubble microscope.
Well, that's something I wanted to see if you could emphasize or expound on the idea that not only does the person, witness has certain rights, and obviously the accused has rights. The accused, one of those rights is to confront their accuser in an open court, and none of those things really correspond with I want to protect my identity, I don't want to be stalked or harassed or confronted online if you're the accuser, but this person is not found guilty yet. They have the presumption of innocence, the accused does. And so part of the whole framework here is that you have the ability to see who's accusing you, what they're saying, and via your attorney, challenge what they're saying. And that's part of why things work the way they do.
Well, and that's one of the fundamental constitutional rights we have. It's the Confrontation Clause. You have a right to compulsory process, to compel someone to be there, and you have a right if someone's going to accuse you to confront your accuser, cross-examine them. But Jeff, now if you were going to be on a jury panel, I didn't like the fact that you say has not yet been convicted.
Yeah.
But
that was a loaded statement,
You got
wasn't
to
it?
watch the media all the time when you're
Correct.
talking about cameras in the courtroom. Now, other distinctions that people don't understand, like the Trump, I was going to say trilogy, but it's grown to a quilogy or whatever it is.
It's a 10-part series.
A 10-part series. But, why are some of the cases televised, other cases not? Federal courts, because of the rules of federal civil criminal procedure, do not allow cameras in the courtroom.
And then that's when you bring in the sketch artist,
The
which
sketch
we still
artist.
see.
Then, but however, most state courts too do. This is interesting. 48 states, Lori, allow cameras in the courtroom, and the only two exceptions are Delaware and Oklahoma. And Oklahoma apparently just don't care because they don't have a rule that says you can or you can't. So I don't know what happens in Oklahoma. Appellate arguments is kind of interesting. The Supreme Court of the United States releases they're not allowed to have cameras in the chamber, but they release the audio of the oral arguments the very same day. So you can actually hear those arguments. In Tennessee, the Court of Criminal Appeals releases those audio recordings in 21 days, and they give people an opportunity to object for releasing that and making it public. The Sixth Circuit Court of Appeals can't have cameras. There's only two appellate circuits in the country, the Ninth and the Second, that allow cameras, and those are in instances of civil litigation. So just remember, when you see those sketch artists, that's typically federal court where cameras are not allowed. But then again, what I find is that creates even more of a media circus because everybody is waiting outside the federal courthouse when you walk in and out with your client, and instead of just being able for the media to see what you've done in court and to have a full opportunity to have excerpts and evaluate the proof, you get barraged with cameras and questions.
Unless you find another way to go out.
Unless you find
And that's
another,
been done as well, hasn't it?
it's been, that's why God made Sally ports in the city county building where you can go in if you're friends with a sheriff. But media really, and it started here in Tennessee, has changed the dynamics of the courtroom.
Yeah, that's what I wanted to ask you, Greg. Like, how does it affect the strategy of an attorney, of a prosecutor, or even how just you operate as a court in general?
I like it because I think it provides accountability. I think judges, prosecutors, defense lawyers, when they know that there are a host of volunteers watching, I think you're more behaved, less likely to throw a tantrum, less likely to be disrespectful to the judge. Judge is less likely to be a little more forceful in his chiding counsel.
But wouldn't you argue that maybe with cameras there that might lend itself to more theatrics?
But now that's what everybody thought. But surprisingly, it's kind of like your mother watching you, which she may be watching you if there's cameras in the courtroom. People tend to be more professional and more behaved. Now, there are extreme cases I've seen where you can tell people, judges on some recent cases, I think in Florida, the Parkland shooting case, I think that the judge was playing to the media. I think that impacted what she was doing and how she was doing it. I think there's some lawyers that suddenly start talking in like a radio voice, and you're like going, "Hey, yesterday that you were just like a normal guy in a courtroom, and now you're like in Pirates of the Penzance." Yeah.
Well, and people accused Lance Ito of really getting a big head, Judge Ito, back in the O.J. case.
Yeah, and so really, what I see is it just makes people more accountable. And if you're the public, you should want, you want to know, courtrooms should be public. Justice is something that is very important. It's just one of our most fundamental rights. And when you impanel a jury and you try a case, they are setting a judgment of a citizen accused, and depending on their verdict, that person's freedom can be gone for months, years, or decades. So it's a very serious process, but I think cameras have been a huge plus.
All right, we're going to leave it at that. Talk more about it at 5:30 tonight, yes?
Look forward to it.
All right, thanks for joining us.
Thank you.